Okay. Next up, we have Mr. Gallagher, item number 4, AB 1974.
All right, thank you, Madam Chair and members, for allowing me to present AB 1974 this afternoon. This legislation clarifies and codifies the procedure for re-recording documents by county recorders. And it's not uniform right now currently across counties, so there are different counties doing different things and may cause confusion. So this just codifies the procedure for re-recording. And I actually have the pleasure of having, when I was a Sutter County Supervisor, I worked very closely with our county recorder, Donna Johnson, who's here to testify in support of the bill.
Thank you for allowing me to be here today. I am Donna Johnston. I am the Sutter County Clerk Recorder, Registrar of Voters, and Clerk of the Board of Supervisors. And I'm here on behalf of the County Recorders Association of California as their Vice President, as well as Sutter County. Assemblyman Gallagher is correct. There is a bit of inconsistency throughout the 58 counties as to how we handle re-recording of documents for some errors. This would allow us to have consistency in that treatment of those documents when they come back in to be re-recorded, and also ensures that there's a safeguard in place for citizens to make sure that they're aware of the fact of any re-recordings that are happening on their property.
Thank you. Any other witnesses in support? Okay, seeing none. Opposition? No? Almost. Okay. Any questions, comments from the committee? Mr. Linder?
So, Mr. Gallagher, thanks for bringing this forward. Creating some sort of a uniformity, wouldn't you say that it chips away at local control?
I think that's a good question, Mr. Linder, but but I think in this case we're just, many people record documents across the state, and we have title companies and escrow companies that are dealing with not just recordings in one county but in several different counties, and so having that uniformity helps smooth the process there, if you will, and so there's not confusion between different counties.
I'll jump in.
What are they tempted to do?
It was in the analysis. Mr. Cooley.
I just want to say this is a good bill. Our recording system, it is designed to give people notice of official documents, and in certain instances the timing of that notice is extremely important. We call it a race notice system as a consequence, and to have a standard rule to deal with this sort of unusual fact pattern when there's a need to re-record is helpful to the smooth function of the system. So I think it is meritorious to bring forward and having a 58 county rule, so anyone encountering this fact pattern sort of knows what the California rule is advantageous and timely. And anyway, very good bill.
Thank you, Mr. Cooley.
Thank you. Other questions from the committee? Have we had a motion and a second on this bill? Yes. We have. Okay. I'll go. Mr. Gallagher, would you like to make your closing comments?
I just asked for your aye vote.
Okay. Secretary, please call the roll. This is a due pass recommendation.
Motion is due pass, and we refer to the Committee on Appropriations. Eggman.
Aye.
Eggman, aye. Waldron. Aye. Waldron, aye. Alejo. Bonilla. Bonilla, aye. Chu. Chu, aye. Cooley.
Aye.
Cooley, aye. Gaines. Aye. Gaines, aye. Gordon. Aye. Gordon, aye. Linder. Aye. Linder, aye. Bill's
Both out.
Madam
8-0
Chair.
thing. Congratulations, Mr. Gallagher.
I'll see you in egg.
That egg's over now.
Oh, we're already done.
We're done. Up next, we have Mr. Mullen.
Thank you very much.
You're welcome, Mr. Mullen. Welcome.
Madam Chair and members of the committee, I want to start the presentation on 2502 by thanking the Chair for the consultation on the proposed amendments and some refinements to the bill here. As you may know, my father served in the Assembly, and from 2004 to 2006, he served as chair of the Assembly Housing Committee. This was a period when housing prices were rising rapidly, especially in the Bay Area, and now we find ourselves in a very similar situation. At that time, in that time frame, the state was building about 120,000 new housing units per year. Current estimates suggest the state is only building about 80,000 units per year at this point. As of today, the state is short approximately 1.5 million units of housing for low and very low income households. Since that time, my father left office for various reasons. Nearly every state program to incentivize the construction of below market rate housing has gone away. Prop 1C, the $2.85 billion housing bond, has long since been spent. Redevelopment agencies, of course, have been dissolved. A state court of appeals has ruled against inclusionary housing for rental units. Given the current level of the housing crisis in many parts of the state, we cannot wait any longer. The time to act is now. Not a day goes by that I don't hear about the housing affordability crisis in my part of the state, and I know it's affecting other areas as well. AB 2502 simply restores local government's authority to enact inclusionary housing policies. Inclusionary housing ordinances require that developers allocate a certain percentage of housing units in a new development to be affordable to low and moderate income households. Inclusionary housing programs have been a key tool for local jurisdictions to produce affordable housing units for working households, seniors, and special needs populations. In 2009, a state appellate court ruling in the Palmer versus City of Los Angeles case indicated that the state's Costa-Hawkins Rental Housing Act prohibits local governments from applying inclusionary zoning to newly developed rental housing. Prior to that ruling, the state had no role in local inclusionary policies. Local governments had long enjoyed autonomy to adopt and implement such policies. Approximately 170 cities and counties had some form of inclusionary zoning in place to address the shortage of affordable housing across the state. These ordinances vary in the inclusionary housing unit requirements, the depth of affordability, and alternative methods of compliance for developers. AB 2502 does not impose any new requirements. It simply confirms that local governments may use inclusionary zoning if local conditions dictate. Inclusionary zoning may not be the right policy for every community in the state, but local governments should have that right to decide for themselves. I want to note that I've met with CBIA and other opponents and believe we had a constructive conversation on their concerns. I told them I am committed to working with them to make sure that nothing in AB 2502 adds any additional requirements to what existed prior to the Palmer decision. It is important that locals and developers retain full flexibility so that the policies meet local concerns while maximizing the amount of affordable units that are built. Joining me at the table is the joint author of AB 2502, the chair of the Housing Committee, Assemblymember David Chu, and a number of other supporters.
Thank you, Mr. Mullen. Thank you for your leadership on this issue. From my perspective, I can't think of a court case in recent years that has been more harmful to our ability as localities and as a state to address our housing needs. The Palmer case, I think, was incredibly misguided, but fortunately, last June, the California Supreme Court upheld the ability of cities to do inclusionary, and I think that's something that is worth remembering. In San Francisco, after the Palmer case, I spent a number of years with local affordable housing advocates thinking about what we needed to do to move forward what was a case that really stalled our efforts. And the fact that 170 cities and counties have had to rely on this important tool that got stymied is what we are trying to address here. I sit not just as a chair of the Housing Committee, but as a member of this committee that I know, as Mr. Linder just suggested in the previous discussion, we want to protect the ability of our local governments to do what they need to do. As Mr. Mullen just said, there's nothing in this bill that requires inclusionary. It's up to any local government to decide if that's a tool that they want, but we need to ensure that they have the ability to do that. So with that, I'm proud to be a joint author on this, and I very much hope that we can all support this important measure.
Support.
Hello, everybody. My name is Patrick Heisinger with the City of San Jose. I'm a Senior Development Officer at San Jose, and I manage the city's inclusionary housing program. For the last 4 years, the City of San Jose has been defending its inclusionary housing ordinance within county, district, the California Supreme Court, and at the U.S. Supreme Court systems. Now that the California Supreme Court has issued its decisions affirming the City of San Jose's inclusionary housing ordinance valid, and the fact that the U.S. Supreme Court declined to review the case further, it is time to clarify state law that gives local jurisdictions authority to adopt and implement inclusionary programs, including those specific to rental development. The City of San Jose feels that AB 2502 would in fact clarify those two things. Moving forward, the two sections of my comments will focus on the highlights that we feel AB 2502 would do, and then I want to talk about a little bit of lost opportunity that we've had over the last 4 years. Addressing the highlights, the AB 2502 will lead to more inclusive communities. By building affordable development units within a development, you will be you have a mix of incomes living there. We feel that's very important. In addition to that, you will start putting affordable housing throughout the community. It won't just be banked to certain areas where land is cheaper and all the affordable housing goes over there. It will be spread throughout the community. So. Low-income residents will have the ability to put their kids through better schools, things like that. We feel that's very key. This tool, we've heard redevelopment being eliminated several times today. This tool would be one tool that will help local jurisdictions meet their regional housing needs. Those are very high numbers, and we need the tools to meet those numbers. In addition to that, inclusionary housing actually supports a different type of, I shouldn't say different, more eligible users. And what I mean by that, the housing department in San Jose, we build a lot of permanently affordable housing. Those focus on very low income to about 50% AMI, even up to 60% AMI. Inclusionary programs can go up to the local jurisdiction can set what their programs are at. And in San Jose, we can actually can house folks that are up to moderate and whatnot. And so it's a true workforce program where moderate income families can be housed, whether it's on the for sale product side or on the rental side. Piggybacking on that, if the city keeps moving forward with its ambitious goals of developing affordable housing and the builders are doing their fair share of housing, it really does become a two-pronged approach of the private market helping out and the local governments doing their thing as well. So over time, you can really compound the number of units that are built. Moving forward, just on the lost opportunity, to try to put some perspective, and I know the last 6 years have been a huge development cycle, not just for the Bay Area, but for many parts of California. But the City of San Jose has approved 16,000 units since 2010. If we had these measures in place at the time, we would have created another 2,100 units. And so that's powerful. And just to put that into perspective, at the same time, our housing department that has a staff and has great nonprofit housing developers, we've developed 2,165 units. So essentially, we would have been able to double our production had we not, but we didn't have those tools to do so. For these reasons, the City of San Jose supports AB 2502. And just finally, I want to say that given the ongoing housing affordability crisis in San Jose, this legislation is a top priority for Mayor Sam Liccardo, and I wanted to bring for the record his letter in support. Thank you.
Good afternoon, Chair and members. Brian Augusta on behalf of the California Rural Legal Assistance Foundation, one of the co-sponsors of this measure. And I will be brief because I think we've heard some excellent testimony so far, but I just want to drive home a few additional points that build on what's been presented already. Number one, this bill authorizes nothing new. It reauthorizes the application of these policies to rental housing. And I think that's a really important point to keep in mind, that the San Jose case, which has been referenced several times, affirmed, the U.S. California Supreme Court affirmed that local governments have the authority to adopt and implement inclusionary policies. The one missing piece right now is their application to rental housing. Every city in California can apply their existing ordinance to the production of single-family homes. The question is, can they restrict rents in that policy? But they can require the production of affordable for-sale products. So the inclusionary zoning is not a question. The question is rental housing, and this bill finally clarifies that we can do that. Now, it will remain true that every local government will adopt a policy or not adopt a policy to implement inclusionary zoning. 170 cities in California have done some form of inclusionary. The vast majority have not. It remains a local decision. It will be a decision that some of the stakeholders who you'll hear opposition from can be engaged in at the local level and help shape that policy to make it one that works for that community, or to oppose the adoption of that policy and not have an inclusionary policy as the majority of cities do. So that is all we're doing. We are not authorizing or mandating anything in this bill. We're simply restoring local control, and we would urge an aye vote.
Good afternoon. Anya Lawler with the Western Center on Law and Poverty, one of the co-sponsors of the bill. And in the interest of time, I'll just echo the comments of my colleague and ask for your support.
Madam Chair, David Jones, on behalf of the City of Pasadena, with late support, thank the authors, and we would like to have the clarity that this bill would have. Thank you.
Marina Wyant with the California Housing Consortium in support.
Michael Lane with the Nonprofit Housing Association of Northern California, proud to be a co-sponsor and strong support.
Pete Noonan, Rent Stabilization and Housing Manager for the City of West Hollywood, representing the city in support.
Sophia Sadot on behalf of cities of San Leandro and Walnut Creek in support.
Florence Valencia, representing the American Planning Association in support.
Kiana Valentine on behalf of the California State Association of Counties, as well as Contra Costa and Marin counties today in support.
Karen Lang on behalf of the Sonoma County Board of Supervisors and San Francisco Mayor Ed Lee, all in support. Thank you.
Thank you. Okay. We'll have people speaking in opposition if there are any.
Come on, you got 3 seats.
Good afternoon. My name is Deborah Carlson. I represent the California Apartment Association. First, let me start by saying we absolutely agree that there's a problem. Housing is just not being constructed at a speed that we need it in our local communities. In fact, CA is sponsoring 4 bills and supporting a half a dozen others. I think I want to clarify a few things. Inclusionary occurs today. With or without this bill, it is occurring. Maybe not to the degree that the sponsors would like, but San Francisco, for example, has a 12% inclusionary and are talking about taking that to 24%. But what's not happening today is that in some of our communities, what's not tied are the incentives that must go along with inclusionary. And this bill doesn't tie those incentives to inclusionary. And to make matters worse, over the last couple of years, our developers and builders are told in some cases that their multifamily housing is too dense. They're told that they need to bring it down. So that's not helping us at all. So in order to get their projects approved, they're being downzoned to some degree, notwithstanding the fact that their construction meets the housing element currently in place in the community. So what we're asking for is that we make very clear that if we're going to continue and authorize these inclusionary zoning programs, that we tie them to the incentives that we believe must be clear in the statute. And for that, today we would ask for a no vote, but we would like to continue to work with the author.
Thank you very much. Next witness.
Good afternoon, Madam Chair, committee members. I'm Silvio Ferrari, representing the California Building Industry Association here today. I feel like I got to start by clarifying a few things. You know, we just heard from the apartment side, and we heard a lot of testimony from the author, joint author, and early support presenters about rental. This bill goes far beyond rental. I am here representing the for-sale market rate builders who can demonstrate in this bill that you are actually taking tools away from us. That is our contention with this. I mean, our members today, right now, work with inclusionary ordinances all the time. There's 170 of them throughout the jurisdictions in California. And we know how to work with them. We can do it. There is great flexibility at the local level right now. You know, but the reality is, this is a very costly program. There are burdens. There are real people who, when these ordinances are put in place, are going to have to bear the cost, and those are new home buyers, for a few people to be lucky enough to draw the ball and get one of these price-restricted units. So fundamentally, inclusionary zoning is a program that says, yeah, we're going to help a few people over here, but we are going to hurt many, many others by driving the cost up on those folks. And this bill articulates a very narrow, very stringent process by which new ordinances must adhere to. One, they must be a condition of project development. And the only, yes, this is an authorizing bill, but the only way this bill authorizes to comply is a build-it-only approach. You must construct the units, and that is the heart of our contention. We are saying right now at the local level, for any program to work, we need land dedication options, we need in lieu fee options, we need density options, we need regulatory concessions. Those are all go into the mix of things that say, okay, at the end of the day, based on this market, this is a program that works. This bill authorizes one way for compliance, a build-it-only, the most expensive, the most costly, the most inefficient way to comply. Additionally, I think the other thing we should be very cognizant of as this moves forward, should it move forward, is that there are 170 ordinances on the books. And most likely those 170 ordinances today had some amount of negotiation tied to them. They had some amount of flexibility beyond what we believe this bill is okay with. What does that mean? Are all 170 of those ordinances legal? Or at some point they're going to have to be revised and people go back to the drawing board? What does that mean? We don't know. But we would say that there are certainly people out there who, if this bill were to pass, would say, that's not authorized. I'm going to challenge that ordinance. I'm going to challenge that project approval. And they're going to be now just throwing lawsuits all over the place. And I know that is not the intention at all. But that is what we believe. So I'll just finish by saying, you know, the Legislative Analyst's Office over the last year has said the single thing we can do to help low-income individuals is to improve the supply of housing across all levels. I mean, right, is really the theory of a rising tide lifts all boats. And we don't believe this bill, while well-intentioned, does that. We actually don't think it increases the supply of housing. We actually think it hinders our ability as home builders to bring supply to the market. So thank you for your time. Would also urge a no vote and do absolutely want to work with the authors moving forward.
And can you, before we move on to the next witness, and to remind everybody that the third witness on the supporting side was very brief, can you show me what the section you're talking about that you feel like confines? Because I heard that argument and I looked for it and I didn't see anything where it said build only.
So on page 2 of the bill, you get down into lines 21 through 27. And this is the establish as a condition of development, inclusion housing requirements which may require the provision of residential units. So let's remember where we are. This is a bill that is authorizing inclusionary, right? That is the presentation and the way the bill has been presented is that this is authorizing language. With authorizing language, the only authorized way that this bill has presented is through the provision of the units, the actual producing, the production, putting the units in place. And you can go to, I mean, and I'm not the lawyer and I'm happy to call the lawyer up, but there is long time established case law that pretty much says the expression of one thing is to the exclusion of another. And that's how courts
if I
often...
could say it, not being an attorney either, it says which may, not shall, may require, correct?
Yes.
Okay. Okay, thank you.
Mm-hmm.
Next witness.
Excuse me, Madam Chair, members of the committee, I'm Ron Kingston, representing several apartment associations, Apartment Association Southern Cities, East Bay, Orange County, North Valley, and Mr. Carlson has asked me to mention, because he was unable to make it, also the Apartment Association of Greater Los Angeles, Santa Barbara, and I do represent Mr. Palmer. There has, not to duplicate testimony, and I will try to be brief, which sometimes is difficult for me. There are a couple things that I think...
Hopefully today's not one of those days.
No. Should we all pray, hold hands, Ms. Eggman? While we appreciate working with the author, we do regretfully remain opposed. Inclusionary is very different than rent control. Inclusionary has a feature in it that authorizes price controls without the ability of us petitioning any local government to increase the rents, to increase the cost of housing at all due to destruction, due to needed improvements, due to some unfortunate events. So make no question about this bill. When you authorize this, It is an authorization for price controls, not just rent control. And as the previous witness mentioned, this is about new construction of for sale housing, new construction of rental. The San Jose case that was discussed, there was kind of, I think, some confusion. The San Jose case was a facial challenge, and it was only on the issue of new construction of ownership housing. It did not test, the court did not have before it the issue of new construction rental housing. The Costa-Hawkins Act is very clear on new construction. In order to provide the most important incentive for new construction housing is to make sure that it is exempt from rent control. That is a major incentive. The discussion here about incentives, there is nothing in this bill that provides any directives whatsoever. Every statewide housing program today that has been considered before this committee, earlier this morning, before Mr. Chu's committee, has information and directives how to implement in a sense, how to corral, how to direct. Density bonus program, you name it, it says this is the prescription that we want you to follow so it doesn't get overboard. The local governments don't get creative. And finally, we just want to close our brief statement, Ms. Eggman, that the point that we are trying to make is, as previously mentioned, 170 cities. What has happened since the Palmer decision? Every city and every city attorney has looked at their inclusionary programs and have made the adjustments. San Francisco, Oakland, you name the jurisdiction, they've all made these adjustments. It's not as if the world fell in and we had a catastrophic event. So we don't see that there's sufficient directive here. The legislature is providing that information so we know what it is, we know the parameters, we know that we have some negotiating ability, which this bill doesn't permit us to do. And once again,
I'll ask you to wrap up.
Yep, we will. This was the final closing statement. That if we are to install or authorize price controls on new construction, think about it very seriously and provide those working parameters, because this is a precedential issue. Thank you.
In a presidential year. Thank you. Next up, others speaking in opposition, please just name an organization.
Late support, sorry.
Oh, late support.
Madam Chair, Julie Snyder, representing the Planning and Conservation League. We believe this will spur development that is environmentally friendly, allow workers to live closer to their jobs. So we request your aye vote. Thank you.
All right, thank you. All right, others speaking in opposition now.
Good afternoon. Anthony Sampson with the California Chamber of Commerce. I came prepared with a 30-minute speech, but I'll decline.
That would be in your favor, sir.
Madam Chair and members, Pat Moran with Aaron Reed and Associates, representing the San Diego County Apartment Association, in opposition. Thank you.
Thank you.
Madam Chair, Dave Melton, California Association of Realtors, in opposition.
Thank you very much, sir. Okay, Mr. Mullen. So I would ask you to speak a little bit about the issues of being too limiting, because certainly a lot of communities have in lieu and other kinds of programs that they set up. And then I would also just ask you to kind of re-clarify, because that was one of my questions: is do we even need this? If people are going on and it's been established, do we even need this?
Madam Chair, thank you, and I too will be brief. Most certainly, we need this. Mr. Kingston mentioned some of the jurisdictions have made adjustments, certainly not all, to my knowledge, that there's uncertainty here with regard to the law in terms of inclusionary. And let me just say, my focus here, our focus, is the rental side of this. It's functionally silent on this residential piece, which was the result, which resulted in court action all the way up to the U.S. Supreme Court not taking a case up. I'm not touching that. We're not touching that. My goal here is new construction of rental markets, allowing local governments to put this ordinance in place, but allowing flexibility. And in the meeting that I had with CBIA and opponents just yesterday, I gave a commitment to work on this issue to clarify. And I could speak from personal knowledge on this, having observed the effects of the inclusionary ordinance in a very positive way in my home community of South San Francisco, where there was flexibility allowed, negotiations with the developer to make sure a project penciled out was activated, but there'd be off-site affordable housing in other communities in my district. There are dollars in lieu that can be given to our local housing trust fund. My goal here is to get units built and ensure a modicum of affordability. So I am fully committed to addressing all of these issues that were raised here today and gave that verbal commitment yesterday.
Thank you. Other questions from the members?
Thank you. I took down a couple notes. I become very concerned when the experts in the industry say that it'll limit supply and creates a burden to them being able to build. So one of the questions that was raised was in regards to the 170 jurisdictions that are currently have some sort of inclusionary zoning, what does become? They mentioned that it's possible that these could be deemed in fact illegal. Is that a possibility, or what do you determine the
if the